Welcome to the M2I Alternative Investments Chat, where we demystify the world of alternative investments and financing for entrepreneurs and investors alike. With these discussions, we hope you're more empowered to unlock new opportunities in your business or portfolio. Hello, and welcome to this episode of M2I Alternative Investments Chat. I'm Erin, sitting here with Erica.
Hello.
And in today's episode, we're going to be diving into Regulation D, specifically the rules that fall under Regulation D 504, 505, and 506. So let's get started. Regulation D, or Reg D, as you might hear, is a Securities and Exchange Commission, the SEC. We talked about that on our last episode a little more. You'll hear that a lot in this space. It's a regulation governing private placement exemptions. Reg D lets companies doing specific types of private placements to raise capital without needing to register their securities with the SEC, which you typically need to do for other securities. The company or entrepreneur must file a Form D disclosure document with the SEC after the first securities are sold. So, Erica, could you tell us a little bit about the benefits of a Reg D offering?
Yeah, so raising capital through Reg D investments involves less difficult requirements than a normal public offering typically would. So it allows companies to save time and sell securities that might not otherwise be able to be issued in some of the cases. So with Reg D, you're raising funds much easier. Mm-hmm. You can buy those, buyers of those securities still enjoy the same legal protection. So it's not like because you're not registering means that all of your, safety net falls out from underneath you.
It's not the Wild Wild West.
No, not the Wild West. You still have legal protections, just like other investments. Mm-hmm. And then Reg D allows smaller companies that can't afford a registered public offering to still access capital, because that's the hardest thing. You need money to do something. You can't just take your company public right out the bat. You're still not going to sell securities that way because they don't know who you are. You don't have any financial, you can't show that it's going to be good, so people aren't going to do that. But you still need to raise those funds to make your investment grow. So the provisions in Reg D also serve as a safeguard for investors in private offerings, allowing them to verify that a company meets the exemption requirements and is not engaging in fraudulent activity. So we talk about research and due diligence. That's still part of it, because we want to make sure that nobody is being fraudulently sold stuff. Yeah, schemed. And then the last thing is it's not necessary to keep Regulation D a secret. Mm-hmm. It's out there everywhere. You can look it online. And then there are directives within this regulation depending on which rules are applied, but many allow offerings to be openly solicited. Mm-hmm. But that's not always the case.
Right.
So with that, let's kind of dive into each of the different regulations that you mentioned at the top.
Mm-hmm.
The rules. There's rules to everything. So let's talk about 504.
Yeah, so warning, this could be a little heady, so there's a lot of information here, but we're going to start off with Rule 504, and primarily this is aimed at facilitating capital formation for small businesses and startups by exempting them from rigorous and costly registration processes required by the SEC for public offerings, which you kind of touched on earlier. This allows that capital raise without all of the hoops to jump through.
Yeah.
And this allows companies to offer and sell up to $10 million of securities within a 12-month period.
So it's not like it's raising a little bit of money. You can still definitely raise some capital for your company with these nice rules.
Definitely. So if we're looking at some of the key features of the Rule 504, so it helps streamline the process. Transactions don't have to be submitted to the SEC, so there's no lengthy waiting periods, and there's no ongoing reporting, meaning you don't have to have any ongoing reporting to the SEC after the sale is complete, and this saves time and resources and allows you to put time and resources into other areas of your business, which could be cost effective for you.
That's really good.
And that leads us right into our next point, which is cost effectiveness. Lack of registration requirements leads to overall lower cost of the offering. Duh. If you don't have to utilize time and money, which, time costs money, to have those things registered, then you can put those things in other places / just save the money altogether.
That's great.
And you can avoid the extensive disclosure and reporting requirements that can be associated with registered offerings. And you don't need as many attorneys to go over the transaction. You don't need as many people to be working on this. You still need attorneys. Hello, you still need attorneys. This is not legal advice.
Get your lawyer involved. Get involved.
But, it can help you kind of reduce the cost in some other areas. And also a great benefit is that you're able to sell to both types of investors. We've talked about accredited investors and non-accredited investors. This rule allows you to sell to both. And there are no limits on the number of investors that you can bring into a single offering. And that could be a huge benefit as well.
Those benefits sound really, really amazing. And I'm gonna now go into the bad side.
The drawbacks.
The drawbacks. With everything good, there's something bad. So some of the drawbacks of 504 are restrictions on security. So investors can't sell to whoever they want, meaning there are a few options available when they go to sell the security. So like when you are buying something on the public market, you're like, hey, I don't really like this stock, I'm gonna sell it. You have the right to do that, and you can just put it up and sell it to whomever. That's not the case with 504. And then not only can you not sell to just whoever, you have to wait 12 months after you purchase date unless the issuer wants to register that sell with the SEC. Again, you might as well just wait, because as long as it takes to get through the government paperwork, filing, waiting, money, yada, yada, it's probably gonna be those 12 months. But that is definitely a drawback. Because if you don't disclose this information, registering it, like if you sell it before 12 months, then you're in breach of blue sky laws, which are related to information disclosure. So a quick definition of these blue sky laws: they're state level anti-fraud regulations that require issuers of securities to be registered and disclose details of those offerings within that state. So if you're gonna, here in Arizona, if you're gonna sell in Arizona has different blue laws, blue sky laws than New York, Texas, wherever it may be. And it's an increased complexity comes when in the form of having to follow these blue sky laws, because every single state is different. Even within this regulation 504, issuers may still comply with applicable state security laws in each state. Like we said, the securities are offered and sold. This may involve filing notices, paying fees, or meeting other state-specific requirements, and that right there adds time to the process.
Yeah.
The effect that the blue laws have on you or offering, though, depends on the state, again, that you're operating in. So every state can kind of be a little bit different. There are some capital raise limits. So like you said, you can't raise unlimited funds. We can only raise up to 10 million. That's just to make sure that you can't conduct enormous transactions with using these exempt rules. They're fine with you raising some money, but when it comes to bigger amounts, they want to make sure you're following the rules. And then if an issuer exceeds this limit, it would no longer qualify for the exemption. And then you'd be subject to having to register your security with the SEC.
Potentially.
And then, have to wait, or you could change to a different regulation, which we will eventually talk about. But yeah, another drawback with this rule 504 is advertising. So generally speaking, you cannot advertise. Markets are generally solicitation or try to sell your security. So for example, you can't pass out flyers, you can't run a TV ad, radio ads. This rule doesn't allow for it. So it can be, since you can't really advertise, you might not get as many investors as you're hoping for. So that's definitely a drawback. However, this is kind of where those blue sky laws might be beneficial, because in certain states, they'll actually allow you to advertise. So again, depending on what state you're registering in, they might say, hey, we don't mind if you solicit. Investment companies, they can't participate in Rule 504, again, because I think a lot of it has to do with the funds raised. And then the last thing is bad actor rules. And we're not talking about J-Lo and Ben Affleck and Geely, Lord. So these rules disqualify provisions that can prevent the completion of an offering. So if somebody involved in the transaction is found in breach of the rules, they're disqualified from participating in the offer. And now if this person actually is a really important role it can get your offering wiped out completely.
Yeah.
So you got to be very careful of who you're involving yourself with to ensure that you can keep your offering going and raising those monies. So that's one rule. Let's talk about 505.
Yeah, okay. So 505, in 2016, the SEC actually phased out Rule 505, but it's still important for us to talk about since that's still pretty recent history that 505 has been phased out. And it was integrated into many of its provisions into Rule 504, which might be why Rule 504 is so long. Previously, it allowed a company to raise up to $5 million in a 12-month period, and they could sell to an unlimited number of accredited investors and up to 35 non-accredited investors. Investors can't resell these securities for 6 months, so opposed to that 12 months that you mentioned earlier, this was 6 months. Companies are prohibited from advertising, and companies must provide certified financial statements to investors. So that's what Rule 505 looked like before it was melded into 504, but still good to mention and also kind of know our history here.
Yeah, because, I mean, it came from somewhere, so.
Yeah, exactly. And then that leads us to Rule 506. The definition or the purpose of this is companies relying on Rule 506 exemptions can raise an unlimited amount of money, which is different than what you had mentioned with Rule 504.
Right.
So that could be a huge benefit for certain companies. There are two distinct options under Rule 506. So there's 506 parentheses B.
Right.
And the company cannot use general solicitation, so no advertising, or market the securities. And the company may sell its securities to an unlimited number of accredited investors and up to 35 sophisticated non-accredited investors. And what sophisticated means, it's kind of up to interpretation, but what is listed is this means they must have enough of a financial background or business background to evaluate the potential risks and rewards of the investment. And the company must be available to answer questions by prospective purchasers.
I mean, that makes sense because, again, if they don't necessarily have to be accredited, but as long as they understand that if they lose this $10,000, they're going to be able to live.
Yeah, exactly. And also understand the risks of the investment, which we suggest for any investor, right? You need to understand the risks. So there's a couple of benefits that are associated with 506B. The first one being not regulated by blue sky laws, which you mentioned earlier. They're typically exempt from state registration requirements, aka blue sky laws, although issuers must still comply with notice and filing fees.
Okay. Which is normally that Form D after the first one, so.
Right. Also, there's some flexibility in investor verification. While they have to take reasonable steps to ensure that non-accredited investors are sophisticated, the verification process is generally less rigorous compared to Rule 506C, where accredited investors must be verified using specific methods, which we'll kind of go into later on. Purchasers can actually self-verify their accreditation.
Right, they're saying, hey, don't worry about me, I got you.
Yeah, and it's up to the person who's running the offering to verify that, or to look into that, or that's on you, but that's a potential benefit because it can help alleviate some of that paperwork and time and money and all that. All right, do you want to jump into 506C and tell us a little bit about that?
So 506 parentheses C, companies actually can broadly solicit in this one. And so they can do radio ads, flyers, emails, anything, and they can get their offering out for all eyes to see.
Right.
So it means that the investor pool is a lot larger. So you can hopefully get more people to invest. So the company takes responsible steps, though, however, to verify that investors are accredited, because they have to actually all be accredited in a 506C.
Got it.
So that does mean that they might have to review your W-2s, your tax returns, bank and brokerage statements, credit cards, and things of that nature. Sometimes this can be viewed as a disadvantage as verifying because it can take up time and money.
Sure.
There are third parties that apps and things of that nature that will help you
Verify.
So the investor can go fill out a form and then they kind of do the hard work for you. But again, you're paying them a fee to get that information quickly. There are some great benefits to 506C. So similar to Rule 506B, offerings under 506C are typically exempt from state registration requirements, those blue sky laws. Although the issuer must again comply with the noticing and filings and fees and all that good jazz. There's fees in everything that you do. So being able to publicly market their offering, though, increases that investor base. So hopefully that means even with those small amounts of fees, your investor pool is going to be so much bigger, and hopefully you'll get a lot more money to raise capital.
Yeah, very cool. So that kind of brings us to the end of the topics we were going to cover today. Just as a reminder, some of the key takeaways that we have from today's episode. Regulation D is a provision that exempts some companies from the registration requirements associated with a public offering, and it gives smaller companies access to investment capital by letting them offer specific types of private placements. There are the rules within Regulation D that allow different types of company to raise money up to certain amounts, which we just covered.
Yep.
And they also lay out limitations for investments by non-accredited investors. A company selling securities under Regulation D must still comply with all applicable state securities laws. So that's a good thing to remember. I hope that if you walked away with something today, maybe you walked away with some info about the rules and also blue sky laws, which is a new topic that we touched on today.
Yep. So again, you always want to remind our wonderful viewers, please seek professional advice for compliance and investment decisions. We do our best to try to cover all the topics, but sometimes...
Yeah. Well, we're not lawyers.
Yeah.
Yeah.
I mean, I could play one on TV if I wanted, but...
Legally Blonde?
Yes.
Yeah.
I object. But again, thank you guys for turning in to episode of M2I Alternative Investment Chats. We hope you have a clearer view now of understanding Regulation D in all of its rules, 504, 505, and 506. Stay tuned for our next episode where we cover Regulation CF and A+. We'll catch you next time. Thanks for joining us. Stay tuned for more insights in our next episode. And don't forget to subscribe to continue the journey with M2I. See you next time.
The content provided in this podcast is for informational purposes only and should not be construed as professional, financial, or investment advice. This podcast should not be construed as an offer to sell or a solicitation of any offer to buy any securities. We strongly recommend that you seek advice from a qualified professional before making any financial decisions.